Good afternoon, ladies and gentlemen. I hope everybody's doing well. We'd just like to extend our sincere apologies for the slight delay. We are currently in a community center, so another program slightly ran over hours, but we are just asking for your kind patience, and we do sincerely apologize for the slight inconvenience. But we will be beginning in the next 10 minutes. We'll be starting our program. We do apologize for this sincerely. Please kindly stay on for 10 minutes or so, and then we will be starting our program. Thank you so much.
Good afternoon, everyone. I hope everyone can hear me. Am I audible? Can I just get a thumbs up if I'm audible? Can anybody hear me? Am I clearly audible? Okay. Thank you so much. Ladies and gentlemen, before we start, we would just like to profusely apologize for the very hefty delay. As I had said last week, we are currently at the Trustee Center, the community center. So there are programs that are run here. The one before ours slightly ran over time, which sort of caused us to, delay the program any further. But we would like to apologize, sincerely apologize for that massive inconvenience. My name is Gerald Pinosi, and I am a legal consultant and legal advisor by profession. And I'm from Legiscore Legal Consultants and Advisors. And we are partnered with Trustee, which is where we are now, and Roscott, which is their NPO. We have partnered with them in order to bring this information to the communities. We are focusing on proper estate planning because that is information and knowledge that we lack, as young people, more prominently as Black people. We lack this information, which is very vital in order for us to sufficiently prepare our estates so that should anything happen to us, you'll know that our children are well taken care of. So the series is called The Legacy Blueprint. Last week, we did touch on the types of unions that are in South Africa, which is something I believe we had to start with, because when you are going to get married, you need to make sure that you are in the right type of union, which will work for you in the future, post the marriage. So hence, we touched on those different types of unions and the different types of marriage regimes, and we will do a quick recap on that. Behind the camera, we have Sedimoso Sukona. She's our moderator. She'll be taking your questions. She'll be answering any questions that you have. She is a qualified IT student and a qualified website developer as well. So if any of you require such services for your company, for your family, please feel free to message her directly on the chat. So moving on, today we are dealing with something that is very misunderstood. We are dealing with trust. Estate planning with trust. A trust is one of the best tools you can use to properly plan your estate. So, yeah, we will be beginning that. Again, we are very sorry for the delay of today. I just hope that everybody will still be able to join us and will be able to be with us until the end of this presentation. Now let's move on to this. Welcome to the Legacy Blueprint. This is a 4-week series. We are on week 2 now. And after the 4 weeks are done, you as an individual should be empowered enough to make a good decision on how you want your estate to be planned. You will have sufficient information to action and make sure that you actually do take these steps to prepare for your legacy, as well as for your, what you are leaving behind for your children and your loved ones and the dependents. So what we're going to cover today, we're going to cover what is a trust beyond the stereotypes, because a lot of people only know trust when it comes to trust fund babies, or when perhaps an administration of an estate is happening, people refer to trust only in those situations. But do you really know what a trust is? We will also be tackling why trusts are such a powerful estate planning tool, why they are so vital in ensuring that your estate is properly planned, and you can also have generational wealth. That is another thing we're going to touch upon today, to ensure that generations after you are are put in a good place to be able to continue your legacy and to also be able to be well off, after you pass away. And another thing is that we're going to be tackling the key players in the trust, just to ensure that you understand who is who in a trust, because there are certain players in a trust, and they each have responsibilities and roles to play within the trust. And we're also going to find the different to look at the different types of trust and when they are used, how trust benefits you and your family, and also the common pitfalls to avoid. So these are the things that you need to avoid doing when you have a trust, because you are at risk of your trust being, invalid, if I could say. So we're going to move on to these. Just a recap of last week. Quickly, we touched upon the different types of unions that are allowed in South Africa, right? So we have civil marriages. That is a traditional monogamous marriage between a husband and a wife. Sorry, just for the disturbance. Thank you so much. We apologize, ladies and gentlemen. There are still people also still coming in. So we do apologize for the slight delay. And also, please don't mind if you hear some footsteps. People are just coming in now. Another thing is, so last week, this is week number 2. This is, the program is called the Legacy Blueprint. It is aimed at ensuring that you plan your estate now while you're still alive, not after while you die. But also, we also have tools so that you can plan your estate after you pass away through wills and trusts and so on and so forth. So last week, we are just doing a recap of last week. We were covering the types of unions in South Africa, because if you are planning your estate, you need to make sure that you marry through the right union, through the right marriage regime, right? So we covered civil marriages. These are the traditional monogamous marriages, one wife, one husband. And you can get married in community of property or out of community of property with and without accrual. Now, there's also civil unions. Civil unions are basically created for people of the same sex. So, gay people, lesbians are able to get married through this union. You can also get married through this union if you are heterosexual couple. So opposite sex and same sex also applies. You can choose civil marriage or civil union if you are the opposite sex. We also covered customary marriages. This type of marriage union allows a husband to marry more than one wife, but that person should not be in a civil marriage already, and they need a consent of the first wife to get married. But the requirements are that the customs need to be recognized, so there has to be a payment of lobola. Whether it's finished or not finished, it is accepted. So it includes polygamous, like I said now, and you need to be 18 and over. There needs to be consent between the two people, and also you need to be competent to marry. So you cannot marry your brother or your mother or your grandmother. Those types of things are what we spoke about last week, that we touched upon. Now, all of these unions, they have the same marriage regime: in community of property, out of community of property, with and without accrual. Now, life partnerships is cohabitation. Some people call it fat and set, some people call it kutipita, whatever it is that you refer to it. There is no automatic legal status. So when you have a boyfriend and girlfriend, you are living together, doesn't matter even if it's 10 years. When you pass away, you're not guaranteed any benefit of your partner. So it's not like when you're living with somebody for more than 10 years, automatically when they die, you're going to get their house or get whatever. How you can protect yourself is through what you call a universal partnership agreement. This agreement states that both of you are life partners. You have chosen to be together. You guys share certain assets. Right. Now, if you want to leave the asset in its entirety when you pass away, you need to leave a will. Make sure that you write your partner down in a will. That is the only way you can benefit. Another way is through unjustified enrichment claims. So if your partner got enriched at your expense, you can claim that from the deceased estate. When your partner dies, you can claim that money. If maybe your partner took your car without your consent and then they enriched themselves, when they pass away, you can claim the value of that car from your partner's estate. You can also claim from their pension if you have sufficient evidence that indeed this person, you are dependent on them and so on and so forth, but that is dealt through the courts. Okay, and then general principles, all unions, prohibited degrees of kinship. What I was saying, there are certain people you can't marry. Like you can't marry your mother-in-law if you're a man, you can't marry your father-in-law if you're a woman, you can't marry your brother, your sister, you can't marry your mother. your son. You can't marry your wife's son or daughter. You can't basically marry your bloodline, but you can marry your cousin and you can marry your sister-in-law or your brother-in-law. Does it make sense? So these are the degrees of kinship, prohibited degrees. People you're not allowed to marry. If you do marry them, your marriage is null and void. It's like it never happened. See. So overall importance, understanding these types of unions is a foundation for effective estate planning, honoring wishes, and preventing disputes. So basically, this whole series, we started it so that we could end disputes. You know, this drama of family houses, people fighting for family houses. We are trying to destroy that mindset, that type of legacy, because it's happening prominently. Everywhere you go, people are fighting for houses, even killing each other. So this series is dedicated to ensuring that it gives you enough information to prevent such from happening. Okay, so we're going to start with our program for today, which is about trust. And I'm just gonna open to the floor, those who are online and who are with us. You guys know what a trust is. It doesn't have to be a right answer. Anybody online, you can type, you can raise your hand. Let us know what a trust. Do you know what a trust is? According to you, what is a trust? Yes. Okay. Yeah, I think maybe the context is different. Yeah? It's not the actual trust, as in like I trust you, you trust me. It is okay. Now, if I answer you, I'm gonna answer it. I'll give someone else. You're not wrong, but the context. Yeah. Those answers are both correct. Okay. And two. Yes, you guys are definitely correct. That is exactly what a trust is. Roughly speaking, not really like we're not going to get into too much of the technical stuff, but a simple explanation. That is exactly what a trust is. So a trust essentially it's a legal arrangement. Okay. I'm going to explain it further step by step. Yeah? It's a legal arrangement. You as the founder, you start a trust. The trust, you have various reasons why you want to start it, but you start the trust, you put in assets in the trust, whether it's money, whether it's a house, whether it's a car, whatever it is. You put it in there for the benefit of someone else. Now, when you put the assets in a trust, they get managed by what you call a trustee. Trustee manages the assets. Sometimes they own the assets, but we will get to that and I'll explain it further. Today's lesson is a little bit complicated, so I just need you to bear with me. If you are lost, just let me know so you can get back because everything is sort of connected. So I'm going through these things step by step. I want you to picture a trust as a box, right? Inside the box are toys. Toys are assets. You bought the toys or acquired them or got them wherever, you put them in the box, right? Then there's somebody with a key to unlock or whatever, who manages the box. That's the trustee. Trustee takes care of the box. I mean, whatever is inside the box and the box itself. Now, the beneficiaries are the children. Let's say that the inside the box are toys. Children or whoever it is that you want, the beneficiary, they are going to benefit from whatever is inside the box. That's basically what a trust is. Okay, so the purposes of a trust. Besides providing for future generations, a trust has multiple purposes. The first purpose is asset protection. You must understand when you put something in a trust, it no longer legally belongs to you. It belongs to a trust. Hence, if somebody sues you, they can't attach whatever is in the trust against you. Understand? So your assets are safe and they are locked away. But however, there are some instances whereby they're no longer safe when it comes to tax, when it comes to insolvency. Okay, but we will get into those things. Another purpose is to support loved ones. Upon your death, untimely death, God forbid, when you do pass away, your loved ones are protected because it is a legal arrangement. It is an instruction of how you want the trustee to take care of the assets so that the beneficiaries benefit. Is everybody still with me? Are you guys okay? Okay. Business succession. People also open trust for businesses in order for businesses to continue. Like I said, you put everything in a box, you get somebody who manages it with the trustee moving forward. If a trustee passes away, another trustee will be appointed. It's an ongoing thing. Understand? Charitable giving. People open trust to give to charities, give to non-profit organizations. That's basically what people do as well. So you are allowed to not give to a person, but to another organization. Okay. Are there any questions so far? Everybody good? More seconds. Everybody's good? Okay, so the legal nature of a trust. The trust is complicated because it's not really like a business, not like a legal, it doesn't have a legal status. You know, when you register a business, you get a registration number and stuff like that, and it's recognized as a legal person. But when it comes to a trust, it's slightly complicated. It's sort of like it is, but it isn't. You understand? When you put things under a trust, they fall under the trust, but the trustees are the ones that control everything. But we will get to that step by step. Now, it does not have its own rights and liabilities like a company. So essentially, it's, you know, a company, you can sue a company and stuff like that, but a trust is different because it doesn't have a legal status on its own. So the assets, rights, and liabilities vest in the trustee in their official capacity. So the trustee is the one that controls everything in a trust. Are you guys with me? Okay, so like I was saying, however, for specific statutory purposes, such as insolvency or tax, a trust may be treated as a legal person. So when by any chance you owe taxes and then the state finds out that you hid things in the trust purposefully to evade taxes, SARS will identify the trust as a legal person so that it can get money from it. So you can't hide behind the trust, especially if you are trying to purposefully evade tax. Or when you are insolvent. Insolvency is when your liabilities are higher than your assets. And what happens is that companies, they sequestrate you. There's something called sequestration. It is a process whereby companies will try and recover the money you owe them, especially if you are insolvent. Okay, but that's another subject for another day. So that is the limitation. You cannot protect your assets 100%, especially for these specific reasons. So we are getting into the different trusts. There's a business trust and there's a family trust. Family trust is the one that is commonly known. They use it to focus on wealth preservation, to protect the assets so that the future generations could still continue enjoying those assets, right? And they are beneficiaries, often created to provide for the needs of dependents, ensuring continuity, appropriate management of assets for family and members. So for instance, if there is a minor, your child is still small, you can open up a trust. In the trust, you can say, upon 18 years old, they will get this from the trust. The trustee will ensure that that happens. You understand? And if perhaps there's somebody who's disabled, maybe a disabled child, you can open up a trust. The trustee will ensure that that money is dealt with properly and it will take care of that disabled child. Am I making sense? Are we still together? Okay. Business trust, the similar thing. Trust, whether private or business, they have the same sort of structure because there's also a founder, trustee, and then there's beneficiary. So they are all sort of the same. It's just that how you use them. If you're using it for business interests, then you can refer to it as a business trust. If you are using it for family, you can write it as you can describe it as a family trust. Okay, so trustees are authorized to carry on a trade or a business for profit using the trustees, the trust assets. They can combine a business endeavor with an estate planning goal. So you can combine the business and the family trust into one. It doesn't have to be separate. Like I said, it's not recognized as a legal person, so you can use it for either or for both. Okay. They are often structured as inter vivos trust. They are less heavily regulated than companies. So an inter vivos trust is a trust that you open while you are still alive. When you pass away in your will, the trust that you open, it's called a testamentary trust. So in your will, you can say, I will put all of my assets in a trust. Once the trust is opened, it's a testamentary trust. Okay. And then tax estate duty. Well, tax savings are less prevalent now. They can still offer estate duty savings if carefully structured, as beneficiaries' rights are generally not vested and does not fall into the deceased estate. So when you put things into a trust, the beneficiaries do not necessarily pay estate duty. So estate duty is when you pass away, there are certain taxes that you need to pay. Because now these assets do not belong to the beneficiaries. They are under a trust, they are protected. So there are certain taxes that you will not be able to pay. Now, as I am not necessarily a tax expert, I always advise people that should you consider getting a trust, you should approach a tax attorney who knows these things, or you can approach an accountant as well to get the proper information, because every trust is different. So I can't give you a general advice on the taxes, things like that. Is there a question? Yeah, there's a question there. No. So, oh, sorry. Thank you, Pabi, for the question. So, Pabi, what happens is that immediately when your husband takes out lobola, there's a ceremony, uncles and aunties meet. After that has happened, as long as you are above 18, is consent. You guys are married in community of property. So immediately after the lobola is taken out, even if he does not finish the payment, you guys are married in community of property. So whether he wants to sign or not, should he pass away, the lobola letter, you can simply use that to prove that indeed he did take out lobola for you. And the state, the law says, customary law says, if somebody takes out lobola for you, they are married to you in community of property. So automatically you are going to get 50% of the estate, of the estate of your marriage. Now, the other 50% will not go to family, it will go to the children. Because if your husband dies without a will, and we're going to cover this next week in detail, hence it's step by step. If he dies without a will, they are going to go to the children. Like I said before, the interstate succession will come into play. So in other words, you're going to keep your 50%, your husband's 50% will be shared to the children. You will be added as one of the children. Whatever is left, they will divide it by the number of children. If it's less than 250,000, then you will get 250,000 from there. First, they will deduct your 250,000. Whatever's left will be shared with the other children. So the law says you get 250,000 or whichever is higher. A child share 250 or 250,000, whichever one is higher. You understand? So that's what's going to happen. If he has a will, whatever is in the will be executed. If he decides to leave you out of the will, you won't get 50% of his 50%, but your 50% is guaranteed. You have 50% even now before you sign. So that's basically what's going to happen. Family cannot, under any circumstances, have access to that, because remember when I said last week, everything that you leave behind goes down to the descendants, goes down, it does not go back up or sideways. If you have children, only your children are going to get whatever you leave behind. So I don't know if I answered you correctly, Fabi. Yes, sorry. Thank you for the question. Thank you so much for the question. So in that situation, it is recommended for you to have a business trust, because it's for the purpose of business, and it is the purpose is to carry on a trade for profit using the trust assets. So it's better to open a business trust, basically. Now, what you can do is you can mix it up as well by saying that because now the business will be an asset of the trust, you can say that the trust must give the children a specific amount, maybe when they turn however old. But for the sake of clarity, because now when you even open a trust, the instruction needs to be clear. Otherwise, it's going to open a can of worms in the future. So just make it a business trust. You can even open two trusts. There's no stopping. One can be for the family. They can both be intertwined, whereby maybe the shares of this is owned by this one, the shares of this is owned by this one. You can play around with it, but it's best to always get legal advice, to sit down with an experienced legal professional to give you the sufficient advice as to how you can work around your specific situation. So I don't know if I've answered you, Pitu. Thank you so much. All right, so now we're going to, what I was saying now, it is flexible. The business trust or even the personal trust, it's flexible when you're setting it up and you're administering the business operations or the family operations. I always tell people that a trust is similar to a will because it starts with an instruction. The will is also an instruction. Trust starts with a trust deed. So it's an instruction. Both of them are instructions, and they're both sort of legal setup because now a trust is binding in as much as a will is binding. Okay, so here is the distinctions. The fundamental difference lies in their primary purpose and operational focus. That's the only difference between the two. So one is for family, one is for business. That's the only difference. They are similar. They all have the same structure: founder, trustee, and beneficiary. So it's exactly what I was talking about now. The three players: the founder, the person who creates the trust, who starts everything, the person who puts assets in the trust. Because now when you put something in the trust, you are saying you want the trustee to take care of it for the beneficiary. You yourself can become a founder, a trustee, and a beneficiary, but there are limitations to that, and we're going to get into that a bit later on. You set the rules of how the trust should operate. So you are the one that starts everything. The trustees, is an individual who is appointed to control and manage the trust assets. Like I said before, in certain situations, the trustee can also be the owner of the assets. But in this case, we're going to say they're only managing it. Yeah, in this case, we're only saying they're going to manage it. They have a fiduciary duty to ensure that they must act honestly and in the absolute best interest of the beneficiary. So it is like a position in a business. They need to make sure that this position, they do it with diligence, with care as well. They need to act in the best interest of the beneficiary. That's their only mandate, to act in the best interest of the beneficiary. Okay. And another thing, they must be officially authorized by the Master of the High Court by receiving a letter of appointment. So any action that a trustee takes without authority from the court through a letter of appointment, it is null and void. So they need to get authority from the court. Now, the beneficiaries are the people who are going to benefit from this box. So like I said before, it's a box, you put things inside of it, and the beneficiaries enjoy the fruit of whatever was inside. Okay. So it can be individuals, you can name them, you can just say for future generations, you can say the firstborn children, whatever it is that you want to do. The trust is up to you. You are the one that sets the instructions. You are the one that says, how it's going to be managed. Okay, so I'd like to call them two flavors of trust. Okay, there's the ownership trust. This is where the trustees become the legal owner of the assets, like I mentioned earlier on. Normally, a trustee is there to manage, but through the ownership trust flavor, if I could say, the trustees are the owners of the assets. But now, they cannot use the assets for their own benefit. They need to use it for the benefit of others. That's the whole reason why you open a trust, because you want others to benefit. You can also become a beneficiary, but there are limitations on that. I will get to that a bit later on. This is the most common type of trust. So the trustee owns the assets. Obviously, many people prefer it that way, unlike having someone own the assets and manage them on your behalf. Right. And then there's another one called the beneficiaries trust. This is when the beneficiaries, the ones that are benefiting, are the ones that own the assets. And the trustees are the ones that manage the assets for the benefit of the beneficiary. Okay. So, yeah, the trustee in this case only has powers to control and manage. They don't have the powers to, they don't own the assets. They only manage the assets for the best interest of the beneficiary. Are we together? Is everybody still okay? Is everybody still okay? When do trusts come alive? The two types of creations of trust. I think I briefly mentioned them earlier on. There is a testamentary trust. This is the trust that gets created when your estate is being wound down through a will. So this trust can only be created through a will. So when you are gone, you decide the trust must be opened, and then you write the instructions of the trust, so that when you pass away, the trust can be opened and managed according to the way you wrote in your will. Okay? So it comes into existence after your death. So it can only come into existence after you pass away. And it's ideal for providing minor children or other dependents who may not be ready to manage the inheritance themselves. So, like I said, anything to do with the trust is for the benefit of others, right? And yeah, an example, I leave my estate to my appointed trustee to hold in trust for the education and maintenance of my children until they can reach the age of 25. So you can put conditions, you can do whatever it is that you want in the trust. Okay. Now, inter vivos trust is when you are alive, during your lifetime, you can open this. It's normally created by a contract. Some say it can be oral, but I always prefer that you write things down. And you do this to a trust deed. Okay. And it comes into existence immediately once the trust deed is signed and the assets are transferred and the trust is active. It's excellent for lifetime asset management, which something like generational wealth, if maybe you're from a wealthy family, or if you have come into a large amount of money, better to put it in a trust so that it can continue for generations to come. But it must be said that a trust needs to be funded by you. When I say asset, it also means money. You have to make sure that there's money in the trust. Trustee holds the office, so the trustee needs to be paid as well. They can't do it for free, unless if you are the trustee or somebody in your family is a trustee and they are doing it from the kindness of their hearts. But they do need to get paid because it is an office, an official office in the trust. And this can potentially help in reducing estate duty. So estate duty is when you pass away, then the taxes that are charged on your estate and stuff like that. So yeah, that's basically it. Are there any questions on the trust, the two types of trust? Any questions? No questions. Okay. So now we're going to get into the power of trustee. I know maybe a lot of you might be skeptical about allowing other people to handle your assets. Maybe you might be scared they might take them or sell them and stuff like that. So this is what we are covering in terms of what their power is, what it is that they are entitled to do. So the duty of a trustee, they manage the property honestly, diligently, and with care, like a responsible business person managing someone else's affairs. So it is their responsibility to make sure that they take care of the assets to the best of their ability for the benefit of the beneficiary. They are supposed to keep proper accounts, and they are supposed to separate the trust property entirely from their own property. So they cannot treat these assets like they belong to them, even if they are yours. You cannot use the assets the way you want. There needs to be a proper account of the usage of the assets. And you should always bear in mind that it is for the beneficiary. It is not for you as a trustee to benefit from. Okay? You should provide financial information to the beneficiaries when reasonably requested. So the beneficiaries are allowed to ask, I want the financial statements from last year on the trust. I need to see what we did with our money, how far our money is, how much there is left, stuff like that. If there is more than one trustee, they must generally act jointly in their dealings unless the trust document says otherwise. So yes, there can be more than one trustee. It depends on you as a founder, how many trustees that you want. Maybe you can have 3 so that whenever there's something, maybe they can vote on it, and 2 to 1. So maybe 3 is a good number. What trustees cannot do, they cannot use the trust assets for their own personal benefit or gain. And they cannot act without official authorization from the Master of the High Court, which is essential. So anything that they do without the permission from the Master of the High Court is null and void. So it would be like it never happened. Okay. Unilaterally change the trust terms of conditions or decide who benefits unless the trustee explicitly grants them power. So they can only change the terms and conditions of the trust, how the trust is managed, only if you as a founder have stated in the trust deed that the trustees are allowed to change the terms and conditions when necessary. Then only can they do that. But if there is no such clause, the trust will run according to the way you have stated in the trust deed. Okay, so are there any questions so far? Are you still with me? You still together? You sure? Yeah, ask questions if you want. You don't get lost. Because I know, that's why I did it step by step. It's a bit confusing sometimes. Is there a question? No question. Okay. Are you guys okay? Okay, so the nice thing about the trust is that you can even include your future children that are not even born yet in the trust. Yeah, you can basically prepare for them for the future so that when they come into this world, they are sorted. So that's the nice thing about a trust as well. Yeah, this is basically what I was saying. The beneficiary of a trust does not need to exist at the commencement of the trust. Unborn persons can be nominated as beneficiaries as well. The trust instrument can designate this, beneficiaries by description. So you can say, my unborn eldest son or whatever it is that you want to put there. And property can be registered in the name of a person in a trust for her children born to be or born from her. Okay. Once the identity of the children is established, the title deed can be endorsed to identify and state the names of the children. So basically, when the child is not there, obviously you don't know their name. So in the trust, you can just say my future children, and whatever name they're gonna get, that's the beneficiary. They will be put into the trust as beneficiary. Then. Okay. Yeah, so let's just move on to the next one. Why trusts are essential for estate planning is what we're going to cover. This is the whole reason why we are doing this, because now we are preparing our estate, we're getting information on how to prepare the estate. So this is why trusts are important to plan your estate properly. Like we said before, asset management and protection, they provide a structured way to manage and safeguard your assets. Like I was saying before, if maybe you did something to someone and then they want to sue you, they can't really attach your house because your house is under a trust. It doesn't necessarily belong to you. You know what I'm saying? So yeah, assets held in a trust can be protected from personal creditors of your trustees and under certain conditions, even your beneficiaries. So these assets are protected. Understand? The beneficiaries are the only ones that are going to enjoy the fruits of the assets, unless if it's got to do with tax issues or insolvency, like I said before. There's a question. I think there's a question. Okay, how you go about it is the same way. Oh, Bobby, thank you so much for the question. Sorry about that. How you go about it, Bobby, is that you need to have a trust prior to buying. It's advisable to have a trust prior to buying the actual property. The reason being is that if you buy the property yourself, now it's in your name, then you open a trust. You're going to pay transfer fee to transfer it into the trust. So it's rather when you have a trust, when you buy it, say, no, the trust is going to take it, pay once rather than paying twice. When you buy a house, you know that at least it's going to go straight into the trust and you're going to pay the transfer fees once and you're never going to pay them again, because the nice thing about a trust is that even when you pass away, it's not going to be transferred to someone else. It's already in the trust. There are no more transfer fees that are going to be paid. That is the benefit of a trust. So if you have a house, get a trust first, put that house in a trust, pay the transfer fees. Once it's in the trust, your children are beneficiaries of the house. They can live in that house and enjoy it, even though it's not going to have another owner, unless the trustees, maybe in an attempt to fundraise, sell the house in order to fund the trust, because now they make decisions. So whoever you're going to choose as a trustee needs to have some sort of financial knowledge on how to use money, because there are certain decisions that they need to make for the best interest of the beneficiary. You can't keep a house if it is bleeding the trust, the fund in the trust, if it's bleeding it. So it's better to just sell it, take the proceeds, invest somewhere else in order to continue the generational wealth. So I don't know if I've answered you sufficiently, Pavi. Yes, they can. Oh, sorry. Mpo, thank you for the question. Mpo, yes, they can do that. Remember, they have a fiduciary duty to ensure that the interests of the beneficiaries are taken care of. If it means that they need to invest somewhere else, if it means they need to sell something that's in the trust, they will. They need to do that, and they have the right to do that, especially if the trustees are the owner of the assets. But even if they are managing them, they need to do that for the welfare of the trust, as well as the benefits of the beneficiary. So they can reinvest it, they can sell something, they can buy something, they can do whatever it takes to ensure that the trust is well maintained. Yeah, thank you. So I don't know if I've answered you sufficiently, but sorry, Mpo. Okay, so I'm gonna post this on YouTube. Some of you who can just Google or search for Gerald Kinosi on Facebook or LinkedIn or Instagram. I'm going to, no, Facebook or LinkedIn. I'm going to post the YouTube link on my pages. So Gerald Kinosi, or you can also look for Leisure Score, legal consultants and advisors. We're going to post the YouTube videos on there as well. Yeah. Philip, okay. I hope you answered, Philip. Good. Okay. All right. To continue, it is there to prevent family disputes. I mean, we know that when somebody passes away, there's a whole lot of, in some cases, there's some drama, family members trying to benefit from the assets of the deceased. You know, it's a typical thing that we are used to, especially when it comes to family houses, you know, people fighting over them and stuff like that. So putting these things in a trust will essentially prevent such things from happening. So when you have this dispute in the family because of ownership, this trust will ensure that that doesn't happen, because essentially it doesn't belong to anyone, but the beneficiary can enjoy the fruits of the trust. The assets in the trust are there to be enjoyed by the beneficiary, but none of them have a right to sell them or to claim that they own them. So this essentially solves that problem. And another thing is that The trustee is the one that's going to be taking care of the assets. So if there's a house that is being put under a trust, the trustee ensures that that house will be well taken care of, will be maintained, will be painted once in a while, and so on and so forth. So that's the importance of a trust. Yeah, and it allows you as a founder to take precise instructions on how you want the assets to be managed and distributed, which will reduce arguments, like I was saying now, after you have passed away. Yeah, so it's going to also provide for your loved ones after you've passed away, ensure that the minors are taken care of, or people with limited capacity, like people within your family, you might have somebody who's mentally disturbed or disabled. They will be able to get taken care of because of the trust which you've put in place. Okay. It also avoids the complexities and potential limits of the state guardian fund. The guardian fund is the fund that takes care of the inheritances of minors. So if somebody passes away, maybe there's no will, that money gets, or the estate essentially gets protected in the guardian fund. When they are 18, then they can go and claim from that fund. And it's a little bit of a complicated process and things like that, but the trust will essentially, eradicate those types of complexity. Okay. Flexibility and adaptability, like I said before, the trust will be managed and will run according to how you want it as a founder. Okay. So it will be run according to your wishes, and it is flexible. You understand? So you can do whatever it is that you want. If it's for educational benefits, if it's for generational wealth, business, it's up to you on how you want it. That is why it's important for estate planning. Okay, before we move on, is there any questions? No questions. Okay, awesome. Okay, so wills versus trust. I did a small comparison between a will and a trust. I said that they are sort of similar. Now, your will deals with assets that are in your personal name at the time of your death. It only comes into effect after your death. It can be challenged for validity or interpretation if not drafted clearly and correctly. Now, next week, we're going to be dealing with wills specifically so that you know how to draft a will, what are the legal requirements of a will, how to make it uncontestable. We will deal with those things next week. So that is basically a will. A trust manages assets that you've already transferred out of your personal name into the trust, either during your lifetime or upon your death. Remember, there's an inter vivos and there's a testamentary trust. Testamentary is when you have passed away. Inter vivos is while you are still alive. Yeah, so what I was saying, inter vivos comes into effect immediately upon its creation. Assets in a well-structured trust are no longer legally your personal property, providing distinct protection and benefits as well, which is what we discussed earlier on. Complement your will by managing specific assets for your complex distributions or long-term care. So basically, there's a difference between a will and a trust. But again, the similar thing is that they provide for the ones that for your loved ones, whether you're living or even after your death. So they are there to provide for them to ensure that they are taken care of after you have passed away. Now, another thing that you can do is when you have life policies and things like that, you can put a life policy, the trust as a beneficiary of the life policy. That's how many people actually create generational wealth. So that when they pass away, that 3 billion rand, that 2 million rand goes into the trust. That's how some people create generational wealth. You can make the trust a beneficiary when you are taking a life cover. Okay. Pitfalls. Now, this is what you must avoid, and I think you just need to listen carefully to this one. Remember when I said earlier on that you can be a founder, a trustee, as well as a beneficiary of a trust. Now, there is a limitation to that, and we will get into that shortly. Now, a sham trust is when you are using a trust as though it is your personal sort of account. You understand? You can't use it in that fashion. although it's not a business, you should treat it like a business. It should have some sort of financial statement. It should have some sort of financial checking. You understand? It should, every amount that goes out should be accounted for. You can't use it for your personal gain because now it will be declared null and void. It is what you call a sham trust. The court will declare it as a sham trust and it will be null and void. You will lose all the benefits, which is asset protection and stuff like that, and you will also lose the tax savings that you can derive from putting your assets in a trust. Okay. Now, when you have a trust, it's possible for you to be a founder, a trustee, and a beneficiary yourself. It is possible, but you cannot be the sole trustee, sole beneficiary of the trust. You can't do that. Remember, the purpose of the trust, you open it to benefit other people. A trust is something that lives on and on. So it cannot just belong to you. So in other words, you are saying you open up a trust, when you die, what happens to the trust then? It can't move forward because you, the only beneficiary, have died. You, the only trustee who manages the whole thing, has died. So it's better to have maybe two trustees and then you can become a beneficiary and put in your children as well. Do not become the sole trustee and sole beneficiary. It's a sham trust and it's going to be declared null and void by a court. Actually, it won't even be, the trust won't be created in the first place. Okay, so lack of trustee authority. As mentioned, if a trustee acts without proper letters of authority from the Masters of the High Court, their actions are invalid. This can lead to serious legal and financial problems. So a trustee needs to ensure that they have permission, they have the specific letters of authority to do whatever action that it is that they want to do. It needs to be backed up by authority. Otherwise, whatever decision that they make will be null and void. It can be reversed, and yeah, it will be like it never happened. But that could put a trustee in very serious trouble. So it's important to get authority. Vague instructions in the trust deed. The instructions need to be clear and precise always. The same for a will. You need to make sure that whatever it is that you want in the will cannot be questioned. So when somebody reads the will, they should not ask themselves questions. It should be clear exactly what it is that you want. Hence, you need the expertise of an attorney who's experienced in these types of things so that they'll be able to create a proper draft for your trust deed so that everything could run smoothly. Okay. Yeah. If it's not clear, it's going to cause a lot of confusion, court time, disputes amongst the family members. So it will essentially defeat the whole purpose of a trust in the first place. So it's important to make sure that your trust instructions are clear to the T. Do not leave anything vaguely, right? And trustees must follow the rules set out in the trust deed and the law. For example, if joint action is required but not followed, decisions can be invalidated. What I was saying now, that you need to get proper authority. If there are two or more than two trustees, they need to agree on one thing. The meeting of minds needs to happen so that they can effectively manage the assets of the trust. Yeah, are there any questions so far? Okay. The slide, what will happen is that we will send you the YouTube link rather, because the slides are our intellectual property, so we can't necessarily give them away, but the YouTube video will have the actual slides on it, so you can actually see it. I don't know, TS, if I've answered you correctly. Other people are still typing. We'll just wait for those that are still typing for the question. Okay. Another thing is that I think we'll email you directly the YouTube link because we have the details. So we will email you the recap of part 1 and part 2 so that you can watch them at your own time. Yeah, I think we will definitely do that. So I'm going to continue. We will answer your questions shortly. Okay, so I'm going to reiterate this as well, even now. Without a valid will, your estate will be distributed according to the Interstate Succession Act. We will deal with this next week so you could fully understand what this means. It basically means the law will get to decide who gets whatever it is from your estate. So in other words, you can't give the people you want to give whatever it is that you want, how you want to give them. You do not have freedom of testation. That's what it's called. That's why they say you are intestate, the opposite of freedom of testation. Okay, upon your untimely death. Okay, so are there any questions? Okay, so in the meantime, I'm just going to briefly explain this to you. So let's just go legal consultants and advisors. We are essentially a legal consultancy company, and we have law firms on our panel. So I'm going to make an example. I'm not going to mention the name, but there is a certain company which is sometimes, the ambassador is a guy called Desmond. I think you guys know. Always like to talk about legal stuff, So that company is a company itself. It's not a law firm, but it has law firms on its panel. So our situation is similar to that. We have law firms and we have lawyers who will be assisting you in court with labor law matters, corporate law matters, family law, which is divorce. What is this? Divorce maintenance. We also deal with what is this called? Okay, I'll come back to that. Protection orders as well, stuff like that. But nonetheless, we also do estate planning, which is what we do now. We do trust, we do will, and we do general legal advisory services. So if you need legal advice, schedule a consultation with us, and we will be able to assist you. Furthermore, we assist you with your labor law matters. If you are being unfairly treated at work, you can contact us, and we will assist you with the CCMA process. We will show that we represent you at CCMA for arbitration, provide you with sufficient defense so that you'll be able to, the prospects are high for you to get an award at the end of your case. And when it comes to corporate law, we deal with compliance. We assist you with contracts, whether it's supplier contracts, whatever type of contract, employment contract. We develop policies for your business. And we do quite a number of things. If it happens that the company is in a legal problem, maybe it is getting sued or anything like that, we assist you with that as well. Our lawyers can be able to assist with litigation at court. Yeah, court procedures as well. We do that. We deal with mergers, those types of things. That is what we do. So if anybody is interested in perhaps, or if you have a question, you can WhatsApp us on that number, the 0670912887 number. You can email us on gethelp@legisco.co.za. So you can definitely contact us. We'll schedule a consultation and we will assist you to the best of our ability. Right. So I'm taking questions quickly. Please raise your hand if you have a question. Then we will unmute your mic. Yeah, we will unmute your mic. So there are some people still typing. We will just patiently wait. So these past the past 2 weeks, this is week number 2, but so far we hope that you have received some knowledge and you're probably on the right track to effectively plan your estate. So now we urge you to complete the rest of the 4 weeks and please kindly share with other people. We will do slide recaps, and those who maybe didn't see today can view this on YouTube. We will be uploading it on YouTube before the end of today, and we will be emailing all of you this copy of this session. So we just urge you to please share with people, get as many people into these sessions as possible, because we believe that they are very important. It is quite imperative that people know these things. There are a lot of other families. I'm not going to mention ethnics or whatever, but there are families that are benefiting from structures like this, and these are families that are wealthy, and they will be forever wealthy because they took steps to effectively plan their estate, and now even their great grandchildren are benefiting. So the same thing could happen to you. Let's just make this step and ensure that we effectively plan our estate. Thank you very much. Any questions? Still typing. Okay, we'll wait. We'll wait. Maybe we'll just wait for another 1 minute. Okay. The requirement. Okay, Pule, with regard to the requirement, I think for a trustee, you just need to have the capacity to do the work. You need to be of age, you need to be 18 and above. But because it's like a job, you need to probably have some sort of knowledge to do it. But again, that can't really be a requirement because trustees are whoever the founder, founder writes in the instructions. The founder can choose a trustee, so they are the founder's choosing. So we can't really say you need to be a specific way or whatever. If a founder says, I'd like you to be a trustee and you agree, then you can be a trustee. There isn't a set requirement for it, but it's a general requirement that you need to have the capacity, which means that you shouldn't be mentally disturbed, to be able to make decisions. You should be of sound mind, and you should be over 18. And my other requirement or my advice is that the person should have some sort of background regarding finances, because you can't put somebody who doesn't know how to manage assets and finances, a trustee. So maybe if there's someone in your family with an accounting background, maybe they might be the best person, or maybe a person in the law field, maybe they could be the best person to become a trustee. But please be aware that trusts are funded by you as the founder. It is possible that you start a trust now and you add things later. It is possible. You can do that. So, but just know that they are funded by you. The trustee needs to get paid as well. You need to make sure that they are paid, unless somebody in the family willing to do it from the goodness of their heart. But yeah, that's basically it. I hope that I've answered you fully. Are there any more questions? It's a long one. Eh? Sounds like a very long question that is being typed. But yeah, I would also like to encourage you to please follow us on social media. Legiscore Legal Consultants and Advisors. We are available on all the social media platforms, Instagram, TikTok, LinkedIn, Facebook. We are there. So please kindly follow us. That will go a long way. Yeah. So no questions. We will just wait 1 more minute. Those who are writing their questions, or maybe you might have typed something and stopped typing, please just let us know if you have a question. Who's still typing? If you guys are okay, you don't have any questions, please throw us a thumbs up. Yeah, thumbs up. Okay. All right, ladies and gentlemen, thank you so much for joining us today. We really appreciate your presence and being here. I understand there's not too many of us, but those that are here, I hope that you got something away from today. And if you have any questions, please do not hesitate to WhatsApp us on the number on the screen and or by email, and we'll definitely get back to you. Those who need assistance, we can also assist you with that. If you need anything that needs lawyers, we have lawyers on our panel. And yeah, we are definitely ready to assist you with any problem that you might have. Thank you so much for joining. We'd like to thank Trustee and Roscott for availing their premises to us. And again, we apologize for that massive delay. We just hope that you do understand with the community center and it's available to everyone. And it just went slightly over time. But thank you so much for being with us today. We hope that you have a great day further. Thank you so much.